Renters' Rights Act, one of the biggest things talked about in the lettings industry over the past couple of years, and as of the 1st of May it will be becoming law. So today I'm going to cover some of the main points that we will be expecting to come in as of the 1st of May. Now, firstly, advertising the property and market rents. Now, whatever the price the property is advertised for must be the maximum that you take. If you receive offers over the asking price, you cannot legally accept these. So there are rent caps moving forward. Likely are going to see an increase in marketed price. Number two is going to be rent in advance. Now, quite a big topic within the UK, and we see it a lot with overseas students, people moving into the country for work as well, paying up front. You will no longer be able to take any payments up front in advance. And in fact, the first month's rent that tenants pay must now have to be paid after the tenancy agreement has already been signed. So a big change there as well. Discrimination against pets is no more. So if a tenant requests to have a pet in a property, you must consider it. If a tenant is already in the property and requests it, you have to respond within 28 days to say yes or no. You must have a valid reason to say no, such as a head lease wouldn't allow you to have pets in a building, not a problem. If you come around saying that you've got allergies, you would have to prove this with a medical note as well. So they're getting a lot tougher on that, and to be honest, majority of our tenants have pets, so well worth considering. Then we have discrimination against housing benefit and supported living. Now, we are no longer allowed to market with no DSS, no housing benefits or anything of that kind, and everyone must be considered, which is 100% fair and should be the case. So if you see agents doing it, you can no longer. If you're a self-managed landlord, you can no longer add this into your advertisement as well. Now, one of the most talked about topics of the Renters' Rights Act has to be the change from an assured short hold tenancy to an assured tenancy, which will all happen between the 1st and 30th of May this year. Now, the main element that will change is your notice periods, and Section 21s will be no more, so you can no longer serve a tenant 2 months' notice. What will replace that is going to be a Section 8 notice. However, you have to serve it under one of 18 grounds. So your most common types of notice will be grounds 1 and 1A, which will be 4 months notice to the tenant. And this is the tricky part for landlords, but you will have to wait until month 8 of the contract is passed. So it will be a minimum of a 12-month contract for landlords. So big change there, and it is the most talked about. Now, don't be worried, because a lot of the breach of contracts, you will still be able to serve notice on tenants for, so non-payment of rent, antisocial behaviour and things like that. So this idea of you can't get tenants out is complete rubbish. There is just a different process around it. Now, there's a lot more that I can go into, but if you need any further information on that, just let me know. There are going to be reletting restrictions. So if you serve a Section 8 under grounds 1 or 1A for possession to either move back into or to sell the property, you will not be able to relet that property for 12 months after, to avoid fake sales or for unjust notices being served. So a big change there, and you have to be certain that you want to serve. So the last couple of points are, we've got AWAB's law coming in, which is actually already in play for social housing already, which is to ensure that houses are upkept to a safe standard. Now, this will be coming to the private rented sector as well. So for anyone that has issues with mould and damp and things like that, you need to make sure that you are addressing these things correctly, as there are now time limits on when you need to address and investigate. So really worth reading up on and making sure that your house is safe and secure for your tenants. Now, one element that has actually already come into play as of the 27th of December 2025 is that local councils now have the authority to investigate private landlords and letting agents at their own power. So they could come into a letting agency, ask to see all the documentation that we hold on file, contact notes from registration, and they can actually do the same with private landlords as well. Now, what they can also do is investigate private residents. So if they believe someone is in breach, they can actually go to the residential property and investigate at their power. Now, this is scary because they will be able to keep that money for the fines, and a lot of councils are in need of money, so it's going to be a quick earner for them, so you must make sure that you're compliant. Now, the last element that is probably the most troubling are the fines that could be handed out to both letting agents and to private landlords if you do not follow the compliance. They start at £7,000 and can go up to £40,000 for any re-offence. So your first offence, £7,000. If you make another one, it could be £40,000. So there's a lot of points here that you need to make sure that you are compliant with. Having a managing agent such as Parker's will squash that for yourselves, and the liability comes onto us. We're trained and we are ready for this. Anyone that is managing tenancies privately at the moment that is concerned or doesn't think that they have the right knowledge at the moment, then please get in contact with us to have a review of your portfolio and see how we may be able to assist. So as ever, if you need anything else, want any more information from us at all, get in contact with your local Parker's office and we will be more than happy to help.